initials CE. On or about March 13th, 2020, in Jefferson County, Kentucky, the above-named defendant, Brett Hankerson, committed the offense of wanton endangerment in the first degree, when, under circumstances manifesting extreme indifference to human life, he wantonly shot a gun into the apartment occupied by initials CN. Count 3, wanton endangerment in the first degree. On or about March 13th, 2020, in Jefferson County, Kentucky, the above-named defendant, Brett Hankerson, committed the offense of wanton endangerment in the first degree, when, under circumstances manifesting extreme indifference to human life, he wantonly shot a gun into an apartment occupied by initials ZF, against the peace and dignity of the Commonwealth of Kentucky. Mr. Foreperson, is that the decision of the grand jury?
Yes, it is.
Thank you. Sir, if you would please randomly select a number.
Division 13.
Division 13. Thank you, sir. The case will then be assigned to Jefferson Circuit Court, Division 13. Madam Assistant Attorney General, do you have a motion with respect to bond?
Yes, Your Honor. The Assistant Attorney General asks for $15,000 full cash bond for the defendant, Brett Hankerson.
I will grant the motion and assign bond in the amount of $15,000 full cash and issue a warrant. That concludes the business of the grand jury sitting for Jefferson County in September 2020. Thank you, ladies and gentlemen. You may be excused. I'm going off the record.
We've just learned 3 counts of wanton endangerment against Brett Hankerson, who fired those shots.
All right, we are going to pull away from, because the grand jury now portion of that has finished. You saw a little bit of our affiliated local news. I want to bring in our own Fox News Jeff Paul now with the latest on this. Jeff, you're with me.
Yeah, Harris, I had a few people kind of shouting in the crowd like only $15,000 when they were reading off the bond. So far, that's really only been the response. I'm going to step out of the way so photojournalist Pat Rothenberg can kind of give you guys an idea of just the scene here. This is Jackson Square in downtown Louisville, and you know, it's fairly quiet. I think people are still sort of digesting what was just read, trying to kind of fully understand what this exactly means moving forward. We do know that a curfew has been set up for the next 72 hours that starts at 6 p.m. starts at 9 p.m. and goes to 6:30 a.m. So that is one of the things that will be working in play as people kind of react down here and probably do a bit of demonstrating. It's really hard to tell because this certainly has been a scene of peaceful protests that sort of set an example for the rest of the nation when other parts of the country were sort of going off the rails. This has certainly been an example of unity and coming together, and you can see that sort of in the faces of all the people who have took the time to come down here. It's really hard to get in here. All the roads are blocked, so the people who are here are very passionate about what's going on right now with this case.
Jeff Paul, I wanted to come to you right away. I knew that you had some shouting and other things going on near you, so thank you for giving us a little bit of that immediate reaction there in Louisville, Kentucky. And I'm going to let you go. We'll come back to you as the news warrants, too, because this is going to take a while, I would imagine, for this just to kind of go. We haven't heard yet from the Kentucky Attorney General, and when that happens, we'll take that live as well. Grand jury indicts 1 police officer. And he's the only one facing criminal charges 6 months after Breonna Taylor fatally shot by police in Kentucky. Grand jury indicts that 1 officer, Hankerson. He is an ex-detective, by the way, on criminal charges. And the grand jury, again, we have not heard, after we heard from that judge, we have yet to hear from the Kentucky Attorney General. So we want to kind of break this down, but also with respect that there are more facts coming as well. One of my favorite people to go to because of his experience on these things is John Yoo, former Deputy Assistant Attorney General. John, thank you so much for being with me today. So we don't have a whole lot of detail, and that judge didn't talk for a long time, and there were three people, three officers, and including a sergeant, that were, we didn't know who would get charged or if anybody would. Your first reaction to one officer being charged, and as you can explain it to us as well, what you understand this will mean.
It's great to be with you, Harris. It seems to me an appropriate indictment from the grand jury. You'll notice that the judge was asking the grand jury in the selection you were playing there about their understanding and what the charges were. Former Detective Hankinson is being charged with murder. It seems appropriate. It doesn't look like what we would call first-degree murder, that he planned and in to kill someone with malice. But it sounds like it's something more like, although this is not what Kentucky calls it, it's what we would generally call second-degree murder, that he was wanton, reckless, indifferent to the value of human life. I believe if you look at the facts from the various investigations, Detective Hankinson was the one who looks like he fired almost his full clip throughout the room. I think he's the one who fired 10 shots into the room without really looking to see who was in there, or if there was any threat. The other two officers don't seem to have fired at that kind of rate. So that actually seems like an appropriate charge to me. Also, I might add, the investigation might not be over. We'll need to see what the Attorney General says. But just because Officer Hankinson has been charged with second-degree murder here doesn't mean that the other two officers are yet off the hook. The investigation may still be continuing. They could still be charged with something else.
Yeah, I don't know if you were able to watch that Zoom hearing that we brought in virtually, and they had sent out a link so that widely people could watch it in the public, because they were trying to get the information out there, John, as quickly as possible to people there in Kentucky. They were bracing with the National Guard. They weren't sure what they would find here, and this is something we have seen over the last few months. This case, 6 months and 10 days old, that people said that they were waiting for justice in that point. The judge at one point said in that hearing, at the very end, John, I'm going to go off the record now. And that's kind of when I thought what you're talking about might come into play. Is this really over completely for those other two officers?
That's a great question, Harris. It doesn't need to be. As you said, they went off the record, which could have been anything like, where should we send the grand jury now, to the judge finding out, are you continuing your investigation and deliberations. I also want to say it's very smart, wise, that the government used the grand jury here, because I hope that there won't be any kind of violent protest, that the community will be accepting of this decision. And that's what the grand jury is. Rather than having a prosecutor decide, the grand jury is randomly drawn from the community to make these decisions. We like to think that the grand jury represents the reasonable view of the people who live there. And I think they made an appropriate decision. Not that Hankinson's guilty, but there's enough information there to go forward with a trial, with a prosecution. And again, as you say, Harris, it very well could be the case the grand jury continues its investigation. They may well charge him with something else. Also, let me also say, just because something's not criminal doesn't mean something's not wrong. And as you know, the city here has already paid out $12 million in a wrongful death suit. That's meant to make up for the wrongness of what happened to Ms. Taylor. But criminal charges still might come for the others as well, but just something less than murder.
John, I am curious, because we have it up on the screen there, 3 counts of wanton endangerment, and you gave some of the details from the no-knock warrant that was issued, and then their entry into the apartment and shots fired, and an estimation in your account of how many that would have been. But when you hear that, I heard you say second-degree murder. When you hear, what does it all mean? How do these charges break down? How are they different? And would a jury look and say, and cherry pick some of this? Or are some of them tied together? Every case is so different.
You're exactly right, Harrison. That's why I think people should withhold judgment until they see that's what the trial is for, to present all these complicated facts. As you said, Harris, there's also a lot of conflicting eyewitness testimony here. There's some accounts. Did the police actually knock? Did they not? Did they announce themselves? Did they not? Did Ms. Taylor's boyfriend, Mr. Walker, fire the first shot? I don't think that justifies firing off a full clip by the police into a room without looking into it. But, that might alleviate some of the guilt of some of the others other than Detective Hanson. We all got to see that come out in the trial. That's what the trial is for. But I think it's important to realize, just because there's a difference between first degree and second degree murder and how you prove it, it's still murder. I think the difference is, did someone plan it out with cold-blooded, what we think called malice of forethought? That's first degree. That doesn't seem to be the case here. But if there's second degree murder, is on this at that moment, in the circumstances, did someone act without regard to protecting human life, which is really the duty of the police ultimately? Did this person, here, Detective Haynes, just start firing wildly without regard to the safety of the people he's supposed to be protecting? And that seems to be what the grand jury thought. I think that is the appropriate charge here.
Okay. I want to include some more things that we know in this case to be facts that might be considered, because I think it's important. So it was March 13th. Louisville police officers executed a search warrant, and they used a battering ram to enter the apartment of Ms. Taylor. By the way, just because I know people have probably read it, you know, on social media. I know Oprah's magazine did a feature. She was a 26-year-old emergency room technician. The police have been investigating two men, John, that they believed were selling drugs out of a house. That house was, in fact, located from the documents far from Breonna Taylor's home. However, the judge had also signed a warrant allowing police to search her apartment because police say they believed one of the men they were looking at had used her apartment to receive packages. Facts have shown that Ms. Taylor had been dating the man that they were looking at for having sent packages from her address. On and off for several years, but had recently severed ties. The new boyfriend, she and her new boyfriend are at home in her apartment when they hear a loud banging at the door. Now, they say they both called out, she and her boyfriend, Kenneth Walker, asking who was at the door. Her boyfriend later told police he feared that it might be her ex-boyfriend. And then what we know, and this is what you're alluding to, police broke the door off its hinges, and Mr. Walker fired his gun once, striking Sergeant Mattingly in the thigh. So now, what you were saying before is that they have to then look for consistency of those facts to see what exactly preceded what this one officer who's been charged with a crime did next.
Yes, and if you're pretend you're in the position of Detective Hankinson or his defense attorney, what they're going to say is, well, we thought this was a valid search warrant. We entered the apartment. We did not. We did announce. Of course, it's all factually disputed. We went into this apartment. We were fired upon. He's going to say it was reasonable for me to respond with the use of force to defend ourselves and to prevent whoever was shooting from shooting anybody else. It's of course very serious if a police officer gets shot. Officers usually will think someone who's willing to shoot a police officer is a threat to anybody else, is a threat to the community. That's why I think when it comes to the trial, it's going to be important. Why did you shoot your whole clip? Why did you shoot 10 bullets? And did you look? Did you look where you were firing? Did you see whether anybody was really any longer a threat? That's where I think the trial. Now, if I were Officer Hankinson's defense attorney, I would tell him, you don't want to go to trial on these facts. You should probably try to reach a plea agreement and plead guilty and try to negotiate over the sentence, because I think firing all those bullets into a room where you haven't really looked, that's with these before a jury. I think a jury could easily convict on those facts.
You know, I want to hit another point again, because I had said you said second-degree murder, but the charges that we are reporting are 3 counts of wanton endangerment. So I'm wondering if how did you get there with that?
I'm sorry, so Kentucky actually doesn't draw distinctions between first degree and second degree murder. They just have murder, or they just have manslaughter. I believe from what I heard from the...
Go ahead.
From what I heard of the Zoom feed, it sounded like they were charging with murder, but then Kentucky, like every jurisdiction, will distinguish between what other states would call first-degree murder, a desire to plan out a murder with malice, or something where you acted recklessly, indifferently to human life. That's what I thought I heard.
Right.
If it's not that, if they are actually
John,
charging with something else.
With respect, let me just interject, because maybe there's some difference here, but it is 3 counts of wanton endangerment, and it's a felony. they're felony counts, but we didn't hear the word murder involved. So is there a nuance that we're missing here?
Oh no, I'm sorry if I misheard what was said on the Zoom feed. If it's not murder at all, then it could be a lesser charge. Sometimes what other states will call manslaughter. It is just reckless endangerment of other people's lives. That is a less serious charge than murder, of course. It still is, as you said, a felony. It could still lead to significant jail time. And I think, again, it's not as important what the charge is called, whether it's under Kentucky law, whether it's called murder, whether it's called manslaughter. As long as you're getting the facts right about what Detective Hankinson did he act without regard to human life in that kind of shooting, and then what sentence is going to be imposed.
Yeah. I want to make sure we get this right, because we kind of depended on those words, and murder was not correct. 3 counts of wanton endangerment, which we have been reporting in the first degree. The penalty 1 to 5 years. It is a Class D felony. The definition: a person is guilty of wanton endangerment in the first degree when under circumstances manifesting extreme indifference to the value of human life, which is, John, what you were explaining to us earlier. He wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. And, you know, via that Zoom, as you say, we're getting some information, but we want to whittle it down to the facts that we know, and those are Class D felony, 3 counts of wanton endangerment. I want to bring in now to join us Jack Brewer, former NFL player and national spokesperson for the National Association of Police Athletic Leagues. Jack, it's always great to see you, and thank you for joining the program. There was a readiness for what would come next and what the street would see as justice, maybe even separate from what Breonna Taylor's family would see. And I know that you work so closely with police officers. What are your initial reactions right now?
First off, I mean, obviously sadness. You know, whenever you see a country divided over a murder like this, I mean, it really is sad. And I think, you know, just as we're on the air trying to figure out exactly the terminology and what it means and the definitions, I mean, this is just going to add to the confusion, because I think a lot of people across America on both sides don't really truly understand what this sentence or these charges mean. And so I think we need to bring some clarity to this situation. I think it is a sad situation, but, you know, at the same time, you know, folks need to take this as an example of the reason why we have our legal system, the reason why we need to wait until these things are presented in front of a court and in front of a jury, and stop just lashing out, letting our emotions lead us. You know, I think that does no good for anyone. It doesn't do any good for the memory of Breonna Taylor, for her family, for the healing of this nation. And I just hope that folks can take a step back tonight. And, you know, we don't need any more violence. We need a call for unity. We need some explanation. I think that's what they're trying to do. But let's let the legal process work itself out.
Yeah, you know, we are awaiting the Kentucky Attorney General to come up. And John, you, former Assistant U.S. Attorney General, Deputy Attorney General, had just been joining me. And I want to make sure that it's very clear what the charges are in this case. They are criminal. They are felony D. Murder is not among them. He thought he had heard, John, you, that on the Zoom coming from the judge inside that courtroom. That is not the case. They are 3 counts of wanton endangerment for an ex-detective, Brett Hankinson. And so those are the charges. And Jack, as you are talking about right now, one thing that John Yu was saying is we're not certain if this is all that will come. There are 2 other officers involved in this being looked at. Will charges come? We don't know. The grand jury could conduct more of that. But as we go forth, you're saying we must, and you're so right, wait for the facts. Some of those facts hopefully will come with more clarity when the Kentucky AG gets set to speak after the grand jury indicted that officer, Hankinson. Jack, you know, it has been a long 6-7 months. It has. The death of Breonna Taylor, the death of George Floyd, it has really been one of those times where it seems like things are building. What does it take, do you think, in your estimation, to get us to the point where we can do those things you're talking about, and that is back away, look at the facts, and have cohesive and open conversation with one another.
We have to ask ourselves, where are we finding our truth as a nation? You know, where is our morality set? Is it set from spirituality? Is it set from the Word of God? Or are we just leading off of emotion? We know that some of these things are injustices, and we know that we need to stand against them. But we can't highlight 1 or 2 or 5 instances across our nation and ignore so many of the other injustices that are happening in our land. We can't highlight one situation over another. And what I mean by that is, we have people getting killed by the hundreds every week throughout our nation and shot. You have murders and you have shootings going through our inner cities. All of that is hate. All of that is violence. And it shouldn't matter just because a police officer pulls the trigger or a regular citizen pulls the trigger. We should all be here standing up to unite around protecting life and bringing justice and liberty and morality back to our nation. But to use these type of situations to divide us. By going out, yelling and screaming, saying Black Lives Matters, Blue Lives Matters, and just creating all this division is not helping our nation. And so until we can all take a step back and really truly see each other as one blood, as the Bible teaches us, and really truly look at each other as brothers and sisters and not just talk about it, but mean it, then we'll start to value every situation. And I don't think there's any police officer out there, I don't think there's any American out there that doesn't want true answers to this, right? You even saw Senator Rand Paul, who stood up. He was the one who stood up to stop these no-knock warrants. And even he was getting harassed in the streets after leaving the White House. And so these are just examples that sometimes we're fighting against people that already agree with us. And that is just not the American way. America was built on unity around our flag, around our nation, and under God.
That is such an important point that you make. That, that we are already talking about things that we should agree on. And, I want to hit something that you said there, because I've been saying it since the death of little 8-year-old Sequoia Turner down in Atlanta, who died at that Wendy's. It was several nights after Rayshard Brooks had been killed there. Her mom was trying to drive around a poorly lit and some signage by protesters of where you can and can't drive there if you're protesting. And someone fired, and that child ended up dead. And, the question then becomes, why does that not get the kind of coverage that death by a person who happens not to be Black, who is a police officer, gets? And, as 2 people of color on the screen, I think that's an honest question to ask. Because in addition to making the National Guard ready, to preparing them in Kentucky for whatever the adjudication of this case ahead will look like, what those charges will look like today, they were readying forces on the ground in Chicago in case there was some sort of reaction there. Well, my goodness, there have been weekend after weekend after weekend after weekend after weekend of shootings and deaths there before Breonna Taylor and George Floyd. We have been looking at a situation of Black on Black crime, oh my gosh, for so many years. And that matters, or it doesn't? Is it a choice? Does it only matter with someone who doesn't resemble you that ends in murder? Or doesn't all of it count?
Unity is not mutually exclusive between a Black shooter or a white shooter. Unity means that we want all people to be unified. Love does not mean you love one color or the other color, or you look at something if it's committed by one race or one segment of the population. Love is love, and unity is unity. And I think as a nation, you make a great point. We all need to hold ourselves more accountable. Hold ourselves more accountable to seeing things in fairness, and not for a political debate, not to pick sides, and really the promotion of victimhood is really what you're seeing right now. We can't promote only things that fit a victim narrative. We have to promote things that also call for accountability, also call for discipline, right? I do not mind going to a group of Black men that have their pants hanging down or that are on the block selling dope or carrying guns, shooting at each other. As a black man, I don't have a problem with telling them to pull their pants up and that they need to act right, because we need accountability and discipline. That's what real leadership does. And just like the police officers, if you're a police officer right now, you should tell any other police officer that's a bad apple or that are doing things to bring a bad name to so many of the great cops. The cops should hold them accountable for it. We all have to do our part as Americans to hold each other accountable, and we have to stop being so soft that we want to tell everybody what they want to hear. We have to stop appeasing, and we have to start leading.
Jack Brewer, thank you very much for being on the program today as we react to the Kentucky situation where Breonna Taylor's case now is moving forward. And one of the 3 police officers who were being looked at, an ex-detective Hankinson, has been charged with 3 felony level charges of wanton endangerment and the loss of her life. We are now waiting for the Kentucky AG to speak after that grand jury indicted. And as soon as this begins, of course, we'll take you live to that lectern right there. I want to bring in Scott Bolden, an attorney and former chair of the National Bar Association PAC. We had a mistake earlier with our legal guest, and I am going to continue the cleanup of that because it is so very important that we get the charges right in all of this. So, Scott, you were already booked on the program to talk politics. I'm going to lean on you now in a legal way. Break it down for me what Hankinson is facing. And by the way, let me let you do that. And while you do that, I'm collecting some more facts on what's coming down as information about Hankinson.
Yeah, your prior legal guest, in all fairness to him, it sounded like manslaughter to me also. I didn't hear the murder charge. But let me just say this, as a former prosecutor from New York City, wanton endangerment is a charge, independent. It's not a lesser included under murder or manslaughter. It's wanton endangerment. In New York and several other jurisdictions, including D.C., we call it reckless endangerment. And so it's a D felony compared to an A, B, C, or D felony. It's a D felony. It's independent. He's not being charged with murder or manslaughter, and he gets 1 to 5 years max. Now, if he's charged with 3, he could get that consecutively, or they could run together if he's convicted. He has not been convicted yet, but I expect people to be completely dissatisfied with this indictment, whether the AG presented the case for this indictment for wanton endangerment, or whether it was an investigatory grand jury that came up with this charge. In other jurisdictions, this would be a manslaughter, but every state has its unique charging system.
All right, Scott, we're going to go straight to the news conference now. The Kentucky Attorney General. Let's watch.
Last month to meet in person with her and other members of Miss Taylor's family, including Miss Bianca Austin and Miss Janiyah Palmer. I want to once again publicly express my condolences. Every day, this family wakes up to the realization that someone they loved is no longer with them. There's nothing I can offer today to take away the grief and heartache this family is experiencing as a result of losing a child, a niece, a sister, and a friend. What I can provide today are the facts, which my office has worked long and hard to uncover, analyze, and scrutinize since accepting this case in mid-May. I urge everyone listening today to not lose sight of the fact that a life has been lost, a tragedy under any circumstances. The decision before my office as the special prosecutor in this case was not to decide if the loss of Miss Taylor's life was a tragedy. The answer to that question is unequivocally yes. There is no doubt that this is a gut-wrenching, emotional case, and the pain that many people are feeling is understandable. I deeply care about the value and sanctity of human life. It deserves protection. And in this case, a human life was lost. We cannot forget that. My job as the special prosecutor in this case was to put emotions aside and investigate the facts to determine if criminal violations of state law resulted in the loss of Miss Taylor's life. This included examining the actions of Sergeant Jonathan Mattingly, Detective Brett Hankinson, and Detective Miles Cosgrove, the three officers who fired their weapons in the early morning hours of March 13th. In working with our federal partners on this case, it was determined that while we would share information to advance our respective investigations, we must also maintain some level of separation to ensure the integrity of each investigation. When examining issues regarding potential civil rights violations, we determined that any such violation are better addressed through a federal-led investigation, and issues involving potential criminal acts concerning the shooting are better addressed by a state-led investigation. With this in mind, our investigation focused on the events that took place in Miss Taylor's apartment on March 13th. In the months since taking this case, our dedicated team of prosecutors and investigators with more than 200 years of combined career experience conducted a thorough investigation to better understand the events that led to Miss Taylor's death. The team is here with me today. I want to personally and publicly thank them for their tireless work. These men and women are true public servants who for months have shown up every day with a desire for one thing, and that is to seek the truth. We decided while we would examine materials gathered by LMPD's Public Integrity Unit, we would need to conduct our own independent investigation and start from scratch in the interest of thoroughness, fairness, and finding the truth. There was no video or body camera footage of the officers' attempted execution of a search warrant at Miss Taylor's residence. Video footage begins at the point that area patrol officers arrive at the location. Therefore, the sequence of events from March 13th had to be pieced together through ballistics evidence, 911 calls, police radio traffic, and interviews. We utilized information from the Kentucky State Police, local medical examiners, as well as working with the FBI crime lab in Quantico to secure a trajectory analysis and ballistics report. Our team conducted interviews in this case and spent thousands of hours examining all of the available evidence. We concluded our last interview in this case this past Friday and began our grand jury presentation on Monday. As long as the case is making its way through our legal system, I can only speak in general terms about our independent investigation and findings. As the prosecutor, I am prohibited by the Kentucky Rules of Professional Conduct from making public comments that could in any way prejudice this case as it moves forward. Each state has different rules about what prosecutors can and cannot say. The Kentucky rules are clear that I'm prohibited from making comments that could sway public opinion or heighten public condemnation of those involved in the case. These are crucial rules to ensure due process under the Constitution. When prosecutors prematurely release information about the case to the public, it can risk justice by poisoning the jury pool, violating the accused's rights to a fair trial, and even jeopardizing the final verdict. The success of our legal system is predicated on the principle that the accused is innocent until proven guilty. Despite passions, opinions, and desire for every detail to be known, the rule of law must apply. Justice must be done. In the early morning hours of March 13th, officers from LMPD executed a search warrant at 3003 Springfield Drive, apartment 4. This was Miss Breonna Taylor's residence. The officers were advised by superiors to knock and announce their presence in serving this specific search warrant. The scope of our investigation did not include the obtainment of that warrant by LMPD's Criminal Interdiction Division. Federal law enforcement partners are conducting that investigation. Sergeant Mattingly and Detectives Cosgrove and Hankinson had no known involvement in the preceding investigation or obtainment of the search warrant. They were called into duty as extra personnel to effectuate the service of the search warrant. They only had information conveyed to them during their prior briefing. Evidence shows that officers both knocked and announced their presence at the apartment. The officers' statements about their announcement are corroborated by an independent witness who was near in proximity to apartment 4. In other words, the warrant was not served as a no-knock warrant. When officers were unable to get anyone to answer or open the door to apartment 4, the decision was made to breach the door. After breaching the door, Sergeant Mattingly was the first and only officer to enter the residence. Sergeant Mattingly identified 2 individuals standing beside one another at the end of the hall, a male and a female. In his statement, he says that the male was holding a gun, arms extended, in a shooting stance. Sergeant Mattingly saw the man's gun fire, heard a boom, and immediately knew he was shot as a result of feeling heat in his upper thigh. Kenneth Walker fired the shot that hit Sergeant Mattingly, and there is no evidence to support that Sergeant Mattingly was hit by friendly fire from other officers. Mr. Walker admitted that he fired 1 shot and was the first to shoot. In addition to all the testimony, the ballistics report shows that the round that struck Sergeant Mattingly was fired from a 9mm handgun. The LMPD officers fired 40 caliber handguns. Sergeant Mattingly returned fire down the hallway. Mattingly fired 6 shots. Almost simultaneously, Detective Cosgrove, also in the doorway, shot 16 times. This all took place in a matter of seconds. In total, 6 bullets struck Ms. Taylor. Medical evidence obtained by our team indicates that only 1 shot was fatal. Further medical evidence shows that Ms. Taylor would have died from the fatal shot within a few seconds to 2 minutes after being struck. Detective Hankinson fired his weapon 10 times, including from an outside sliding glass door and through a bedroom window. Some bullets traveled through apartment 4 and into apartment 3 before some exited that apartment. At the time, 3 residents of apartment 3 were at home, including a male, a pregnant female, and a child. There is no conclusive evidence that any bullets fired from Detective Hankinson's weapon struck Ms. Taylor. The KSP ballistics analysis did not identify which of the 3 officers fired the fatal shot. After receiving that information, I asked the FBI crime lab to conduct its own analysis to see if they reached the same results. The FBI ballistics analysis concluded the fatal shot was fired by Detective Cosgrove. Our office looked at both reports to determine if there were major differences in the procedures used by each lab that would have led the FBI to identify who fired the fatal shot. Both law enforcement agencies use similar equipment and analysis, and each lab is highly respected for their work. There was nothing our investigators could point to, nor anything provided by the respective agencies that directly explains why one lab made the call while another did not. I think it is worth repeating again that our investigation found that Mattingly and Cosgrove were justified in their use of force after having been fired upon by Kenneth Walker. Secondary to this justification, the KSP and FBI ballistics analysis reached different conclusions, creating a reasonable doubt in the evidence about who fired the fatal shot. I certainly understand the public's desire for answers, and many have questioned the length of the investigation. Simply put, we had to try every means necessary to determine who fired the fatal shot before the investigation could be completed. With a thorough and complete knowledge of all evidence collected in this case, lawyers with our Office of Special Prosecutions presented the findings of our independent investigation before a grand jury comprised of Jefferson County residents beginning on Monday and concluding today. In Fletcher v. Graham, the Kentucky Supreme Court said that the grand jury has competing but balanced functions. On the one hand, its purpose is to investigate allegations of criminal conduct and determine if there is probable cause to believe that a crime has been committed. On the other, the grand jury serves to protect the public against unfounded criminal prosecutions where probable cause is lacking. The grand jury is unique in our criminal justice system because it operates independent of the court and the prosecutor. The hallmark of the grand jury is its independence from outside influence. This independence is necessary to ensure that justice is done both for the victims and for the accused. After hearing the evidence from our team of prosecutors, the grand jury voted to return an indictment against Detective Hankinson for 3 counts of wanton endangerment for wantonly placing the 3 individuals in apartment 3 in danger of serious physical injury or death. The charge of wanton endangerment in the first degree is a Class D felony, and if found guilty, the accused can serve up to 5 years for each count. Kentucky law states that a person is guilty of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. My office is prepared to prove these charges at trial. However, it's important to note that he is presumed innocent until proven guilty. During the last 6 months, we've all heard mention of possible charges that can be brought in this case. It's important to understand that all the charges that have been mentioned have specific meanings and ramifications. Criminal homicide encompasses the taking of a life by another. While there are 6 possible homicide charges under Kentucky law, these charges are not applicable to the facts before us because our investigation showed, and the grand jury agreed, that Mattingly and Cosgrove were justified in the return of deadly fire after having been fired upon by Kenneth Walker. Let me state that again. According to Kentucky law, the use of force by Mattingly and Cosgrove was justified to protect themselves. This justification bars us from pursuing criminal charges in Miss Breonna Taylor's death. The truth is now before us. The facts have been examined, and a grand jury comprised of our peers and fellow citizens has made a decision. Justice is not often easy. It does not fit the mold of public opinion, and it does not conform to shifting standards. It answers only to the facts and to the law. With this in mind, we must now ask ourselves, where do we go from here? Will we continue to prosecute the charges brought in this case as it now proceeds through the justice system and moves to trial? That is our responsibility. And this will be done while the FBI continues its investigation into potential violations of federal law. I know that not everyone will be satisfied with the charges we've reported today. My team set out to investigate the circumstances surrounding Ms. Taylor's death. We did it with a singular goal in mind, pursuing the truth. Kentuckians deserve no less. The city of Louisville deserves no less. Every person has an idea of what they think justice is. My role as special prosecutor in this case is to set aside everything in pursuit of the truth. My job is to present the facts to the grand jury, and the grand jury then applies those facts to the law. If we simply act on emotion or outrage, there is no justice. Mob justice is not justice. Justice sought by violence is not justice. It just becomes revenge. And in our system, criminal justice isn't the quest for revenge. It's the quest for truth, evidence, and facts, and the use of that truth as we fairly apply our laws. Our reaction to the truth today says what kind of society we want to be. Do we really want the truth, or do we want a truth that fits our narrative? Do we want the facts, or are we content to blindly accept our own version of events? But we must also remember the facts and the collection of evidence in this case are different than cases elsewhere in the country. Each is unique and cannot be compared. There will be celebrities, influencers, and activists who, having never lived in Kentucky, will try to tell us how to feel, suggesting they understand the facts of this case and that they know our community and the Commonwealth better than we do. But they don't. Let's not give in to their attempts to influence our thinking or capture our emotions. At the end of the day, it is up to us. We live here together. We work here and raise our families here together. I urge those protesting on the streets to remember this. Peaceful protests are your right as an American citizen. Instigating violence and destruction are not. I've spoken with both Mayor Fisher and Governor Beshears in the days leading up to this announcement, and I urge them to do what is necessary to maintain law and order and to protect our cities and our people. We have a long road ahead, both as we pursue this case through the criminal system and as we address the pain in the Louisville community. I'm committed to being part of the healing process. When tragedy occurs, we must mourn. We must also do everything we can to prevent it from happening again. Today, consistent with that view, I'm announcing that I will create a task force to review the process for securing, reviewing, and executing search warrants in Kentucky. The task force will consist of a variety of stakeholders, including citizens, members from the law enforcement community, representatives from the judiciary, defense attorneys, and elected leaders. I'll be issuing an executive order in the coming days to create this task force. I believe conducting a top-to-bottom review of the search warrant process is necessary to determine if changes are required and establish best practices. You have my word that I will also vigorously prosecute the criminal charges announced today. I can assure you that my team of prosecutors will continue to give this case their attention and time. We'll also continue to support the good men and women of our law enforcement community who put their lives on the line every day to protect and to serve. And I will fight for those across our state who feel like their voice isn't heard, who feel marginalized, judged, and powerless to bring about change. In a world that is forcing many of us to pick a side, I choose the side of justice. I choose the side of truth. I choose a path that moves the Commonwealth forward and toward healing. You have that choice as well. Let's make it together. Thank you, and God bless. I'll now take some questions. I won't get into the specifics of the makeup of the grand jury.
You mentioned that Breonna Taylor received like 6 bullets. You identified the one that killed her. Who shot the other 5 bullets? Did Hankinson bullets get in this case?
Based on the evidence, there's nothing conclusive to say that Detective Hankinson's, any of his bullets hit Miss Taylor.
I'm just curious what your message would be to the family and those who support the community, because based on what you're saying today, the grand jury basically found that none of the officers involved are directly responsible for the violence.
Well, as I said from the beginning, and I appreciate that question, This is a tragedy. And sometimes the law, the criminal law, is not adequate to respond to a tragedy. And I fully acknowledge that. And I know many that are watching today and those that are listening recognize that as well. But the response is that the grand jury was given all of the evidence, presented all of the information, and ultimately made the determination that Detective Hankinson was the one to be indicted. Grand jury proceedings are secret, and so I'm not going to get into the specifics of details about that proceeding. What I will say is that we presented all of the information, and they ultimately made a determination about whether to charge. In this instance, they decided to indict Detective Hankinson. I'm sorry, say that again?
When it comes to officers firing back in self-defense, do you think the current state law needs to be changed with cases like this?
Well, what my role as the special prosecutor in this case was to provide the information and facts to the grand jury. Detective Cosgrove and Sergeant Mattingly were justified in returning fire because they were fired upon. I'll leave it to others to make determinations. We have vigorous self-defense laws in this state, and that is something that existed prior to this case. I'll let others make judgments about that. Yes, sir.
One big question surrounding this case is whether or not the officers knocked and announced their presence. Talk about the evidence that you came to that they did announce their presence.
Yes, the statements that were made by officers there the night or the morning of March 13th show that they did knock and announce. The important point here is that information was corroborated by another witness who was in close proximity to apartment 4, who corroborated that information and said that there was a knocking and announcing by the officers. The witness was a civilian.
If a wanton takes place while there is a death involved, would there not be a manslaughter charge? If there was a death that occurred during a wanton endangerment?
Well, Chris, to your question, I think it's important to step back and recognize that what we did was uncover all the information and facts related to the morning of March 13th, and then provided that information to the grand jury. The grand jury had every piece of detail needed to make their assessment and their judgments, and ultimately their conclusion was that the decision needed to be made to indict Mr. Hankinson.
Mr. Cameron, Rukmini Kalimaki with the New York Times. Right here, sir.
Yes, sir.
Hi, 2 questions for you. Number 1, you said that she was shot 6 times, yet her death certificate says 5. Can you please explain the discrepancy? And the second thing is, journalists in this room, myself included, have taken apart that apartment complex looking for witnesses to the point that you made about the knocking and announcing. Of a dozen witnesses that I spoke to, only one, a man who was directly upstairs, heard them announce. Do you think that's enough in the middle of the night when somebody is asleep for just one person in a tight-knit apartment block to have heard that? Is that a sufficient way of announcing?
Well, let me try to answer your second question first. Your question was, is it enough for me? I think the more pertinent question is, what was the evidence provided to the grand jury? What was sufficient for their purposes? They got to hear and listen to all the testimony and made the determination that Detective Hankinson was the one that needed to be indicted, knowing all of the relevant points that you made. As to your first question, can you repeat it one more time?
Her death certificate says 5, and yet you are saying 6. Today's the first time I'm hearing 6.
Yes. So there is a bullet that was lodged, and bullet might be too generous a term. There was an object that was lodged into one of her feet, and so that is what is being referred to as the 6th, I guess, projectile.
Are you going to release the full grand jury report?
Can you say that one more time?
Are you going to release the full grand jury report?
Well, I am, right now, because there is a pending indictment, I think it is our practice, and because there is an ongoing FBI investigation, to revisit that question, but at this point, I don't think it's appropriate for us to release any information.
Just for clarification, you said it took 10 times outside apartment 4 and into apartment 3. So who said evidence any of those shots did Taylor? Can you expand on that a little bit?
Well, that is what the evidence shows, is that there was nothing conclusive to demonstrate that any of his bullets hit. Well, again, all the evidence was given to the grand jury, and they made the decision that one, endangerment was the charge to file or to indict against Mr. Hankinson.
Okay, and thank you.
Yes. Well, your last question about providing information, in any investigation, criminal investigation, the best practice, and this is whether on the state or federal level, is to not make too many specific comments about the investigation because you do not want to compromise that investigation. There are also ethical considerations as investigators and prosecutors that we're responsible to abide by as well. Some of those obligations continue now because we have a responsibility to pursue the prosecution against Detective Hankinson. It's my judgment very early on that we needed to take this case in the Attorney General's office. As you know, the Commonwealth's attorney was conflicted out of this case because of another matter that he was pursuing. I could have farmed the case out to another Commonwealth's attorney in one of our 120 counties. Instead, I did not do that because the resources that we have to bring to bear and the relationships that we have with our federal partners, in my judgment, were needed to uncover the truth in this case. And part of the reason the investigation took so long is because we needed to make sure that we were doing a thorough job of looking at all the facts and gathering all the materials, interviewing witnesses, making sure that all of our people felt confident in their presentation to the grand jury. I will remind you, as late as Friday, we were still interviewing people in this case. And so the length of it is because this case deserved thorough and fair analysis. That was needed and deserved by Breonna and by her family, for the officers involved, for the community of Louisville, and for the Commonwealth. We needed to have a thorough investigation. We also got the FBI involved in terms of the ballistics report. We needed additional, their ability to scrutinize and make an independent assessment as well. And so the length of the investigation was a reflection, I hope people understand, of how important it was that we got this right. We didn't want to rush it, and we did not. And I'm grateful to the team that is behind me for the work that they did. Look, over 200 years of combined experience. These are prosecutors and investigators who don't care about political distinctions, don't care about influence in any particular regard. What they care about is the truth. And we presented that to the grand jury.
Sir, I'm sorry.
I'm sorry. I won't get into what our private conversation was. Yes, ma'am.
Yes. What do you say to people who say this is just another example of the Black community not getting full justice? And what specifically do you plan to do to calm a community that's long been hurting? And do you understand that anger that people might feel?
I certainly understand the pain that has been brought about by the tragic loss of Ms. Taylor. I understand that as a Attorney General who is responsible for all 120 counties in terms of being the chief legal officer, the chief law enforcement officer. I understand that. I understand that as a black man, how painful this is. And which is why it was so incredibly important for make sure that we did everything we possibly could to uncover every fact. And I know, look, this team, myself, the members of the representatives of the Attorney General's office have taken a lot of criticism and scrutiny. But that scrutiny in many ways was misplaced because there was not a day the people in this office didn't go to sleep thinking about this case, and it wasn't a day where the first thing on our minds is getting to the truth in this case. And obviously, again, the criminal law is not meant to respond to every sorrow and grief, and that is true here. But my heart breaks for the loss of Miss Taylor, and I've said that repeatedly. My mother, if something was to happen to me, would find it very hard. And I've seen that pain on Miss Palmer's face. I've seen that pain in the community. And what our responsibility in the AG's office was to make sure that we uncovered every fact, that we utilized every resource that we could bring to bear to uncover the facts and the truth, and that's ultimately what we presented to the grand jury. On the question of what I'm going to do, I've talked to partners in the community about helping to be a constructive member of any conversations moving forward. I recognize in my remarks, I mentioned the fact that we'll be establishing a task force in the coming days ahead to look at best practices for warrants. So there is a lot that I can do in this platform to help.
Okay, sir, this is Maria Sicchetti with the Washington Post. Just had a couple of quick questions.
I hear your voice. Okay.
Hi, sorry, over
No,
here in
that's
the
okay.
back. Just wanted to double check, were manslaughter, did the grand jury ever consider the charges of manslaughter, reckless homicide? And if not, could you please explain why? And do you anticipate any other charges in this case?
I apologize. Could you say that a little louder?
Sure.
I think I got...
Sure. Did the grand jury ever consider manslaughter or reckless homicide or those kinds of charges? And if not, please explain why. And do you anticipate any other charges, or is this it?
I won't get into the specifics again of the proceedings themselves are secret, but what I will say is that our team walked them through every homicide offense. It also presented all of the information that was available to the grand jury, and then the grand jury was ultimately the one that made the decision about indicting Detective Hankinson for wanton endangerment. I think that in terms of what happened the wee hours of March 13th, in terms of that particular or specific date and what happened that night in the apartment, I think it is unlikely that there will be any additional prosecutions that come from that event itself.
Attorney General, so can you go into the confusion over the fatal shot that was fired, and kind of what the issue was there in terms of determining that? And then also, did you present to the grand jury with any charges against Mattingly and Cosper?
Well, so as to your first question, what I think you asked about was
the fatal shot.
yes, the reports that were provided to us by the Kentucky State Police and then the FBI as it relates to ballistics. So initially we got the report from Kentucky State Police, and it was inconclusive about making the determination into a fatal shot. And so again, with the relationships that we have with our federal law enforcement community, namely the FBI, I thought it imperative that we utilize that resource. And so they undertook an independent analysis and review of and conducted or provided a ballistics report. There is nothing that this team was able to glean suggesting that there was an objective reason for why FBI was able to conclusively or definitively state that Mr. Cosgrove fired the fatal shot. Both, again, KSP, their lab, well regarded, well respected, FBI, equally regarded and respected. That said, it certainly creates some issue in terms of providing that information to the grand jury and providing that at any subsequent prosecution. And so it was, from our judgment, important to provide both of those to the grand jury and then ultimately let them make a determination about what to do with that information.
Were they presented with charges for Mattingly or Cosgrove?
I'm sorry?
Mattingly and Cosgrove. Were they presented with any charges for Mattingly or Cosgrove?
Well, what I would say is that they will walk through all the homicide offenses, and with that information and the information and facts that were provided to them that we uncovered in our investigation, they made the determination that Detective Hankinson was the one that needed to be indicted here. Yes, ma'am. So what I will say is there's obviously I don't want to get into the proceedings related to Mr. Walker. That's a separate, so I'm not going to have any comment on that. This team behind me presented to the grand jury. And your other question was about the racial makeup of... Well, I'm black, and I speak for the entire department. And I hope that will satisfy that question. Yes, ma'am. Yes, ma'am, I'm sorry.
I know that you said the investigation has obviously taken months and it was presented to the grand jury Monday. Can you tell us, when did the grand jury actually, how long did they deliberate? Did they begin on Monday or did they begin Tuesday? And that was this week, correct?
The grand jury was presented with the information today. I won't get into the specifics of when they began their deliberations, but I will say that they started early Monday and concluded sometime before noon. And so they heard everything they needed to hear. We didn't withhold anything from them. And I hope that satisfies your question.
General, can you tell me a little bit more about this task force? You know, Senate President Stivers and Representative Scott are introducing warrant bills for the next legislative session. Are they going to be on this task force perchance? And will you be taking some of the information from the bills they pre-file to work with on this?
Well, I don't want to put, obviously, the cart before the horse, but I did mention in the remarks that we are certainly going to have elected leaders on this task force, and I imagine that some of the policy questions and some of the policy proposals that have already been put forward and have entered into the public conversation will be a part of this task force. But I want to make sure that people recognize that this task force is being established not to demonize any one side or any one department or agency. I think it's a healthy thing for the Attorney General from time to time to be a part of a conversation with all 120 counties. I'm not talking or singling out any county specifically, but with all 120 counties about best practices that can be utilized. I had a recent conversation with somebody that said there is always room for improvement. I think that's important in any industry, important in any job. And so as part of my role as the Attorney General, I certainly recognize the part I have to play in making sure that all of our systems in government are improved upon, whether it be because of a particular matter that occurred or because from time to time it's just the responsible thing to do.
Did any of the officers ask?
Sorry, Joe.
Did any of the officers ask to testify or present evidence to the grand jury, and were any allowed to?
Well, what I'll say on that is, again, I don't want to get into the specifics, but testimony was heard by the grand jury of all sorts of witnesses and folks. And so, again, all relevant information was provided to the grand jury for them to make their assessment. Yes, sir.
When you look at the analysis of the path of the bullets, how was it that Kenneth Walker, who fired the shot at the officers, was not hit, and Breonna Taylor was hit so many times?
Well, that's part of the tragedy here. And again, I don't want to get into the specifics, but the fact that she was hit breaks my heart, and it breaks the collective heart of all the country. But I don't want to get, because we have now a open prosecution, I don't want to get too into the details of the trajectories themselves.
Two follow-up questions. One, I understand that the names of grand jurors aren't released, but what rule or standard prevents you from releasing the racial and gender makeup of the grand jury? And number two, you mentioned that Cosgrove fired the fatal shot, but could you clarify how many shots in all that hit Ms. Taylor were fired by Mattingly, and how many shots that hit Ms. Taylor were fired by Cosgrove?
Well, as to the last question, inconclusive in terms of how many shots from each officer. We weren't able to identify with that level of specificity. As to the question about the makeup of the grand jury, we might be able to, I need to confirm on that front about. Yeah, you know, the fact that this has received so much scrutiny, I think it'd be inappropriate for me to share the information about the makeup of the grand jury, just to the extent I can protect them.
Would you release the investigative file or recommend that LMPD release it?
Well, look, the role that we now have is to pursue the ongoing prosecution against Detective Hankinson. And so I think it would be irresponsible at this juncture for this office to release any sort of file, again, because we have this ongoing prosecution. And I'm not going to comment on, and I think I certainly shouldn't be recommending, again, because of the ongoing prosecution, any sort of recommendation as to relates to a release of a file.
We're going to have time for 2 more questions.
Oh, Daniel, okay. Well, I certainly don't think that whether it's the grand jury or our responsibility as the investigators or prosecutors, it's to find the truth. And so when folks from outside of the Commonwealth suggest or make their preferences or their opinions known, it should have no bearing on our role as prosecutor and as investigator and fact finder. Even with folks within the Commonwealth, again, this is a tragedy. I don't want to lose sight of that, but we do have a responsibility to look at the facts as they are, and we can't be in the business. I don't think we want a justice system that is in the business of fashioning facts or laws to a particular narrative. We have to be in the business of presenting the information to the grand jury and ultimately allowing them to make a decision about what to do subsequently.
Last question.
Yes, ma'am. Far in the back. I apologize. Actually, we'll take these last 2 here. Okay. So either one. Good start. Sorry.
Thank you very much, sir. I wanted to ask if you, if you believe personally that someone should have been charged with homicide or one of the similar charges in this case, and if you could please walk us through what happened after the officers knocked on the door. Did they hear an answer? How long did they wait before everything erupted. So both of those questions, please, and thank you very much.
As to your first question, again, this is about what the grand jury decided. One of the misconceptions out there is that the Attorney General's office was in the business of making charges, and that's just simply not the case under Kentucky law. Our role is to present the information to the grand jury. We dispense with that responsibility. We did it after a protracted investigation that uncovered all of the facts. That was our role. That was our responsibility. And we presented everything to the grand jury for them to ultimately make a judgment about what to do next. And in this case, in this instant, they decided to indict Detective Hankinson. As to your other question about what was provided to the grand jury, I can't get into the details of the specifics on that particular issue. Yes, ma'am.
Yes, sir. In the beginning, you said that you spoke with Breonna Taylor's family today. I know you can't tell us word for word what they said to you, but how was the news received?
Well, it was a hard meeting, and I won't go any further. I won't elaborate. But it was a difficult meeting, and look, when I ran for this office, I ran because I had some singular ideas in mind, and you never know exactly what issues you'll be presented with, and what challenges you'll be presented with. And today was one of those challenges, to have to sit in that room and provide the information to Ms. Palmer and to other members of the Taylor family. It's been a difficult day. This is a difficult day for everyone standing up here. This is a difficult day for those here that have to report this. And it's a very difficult day for Louisville, all of the Commonwealth, all of the country. I recognize that. And I certainly recognize the responsibility that I have to help in the healing process. As I noted in my remarks, I hope that those that are home watching, those that perhaps have ideas about being angry or pained by this decision, I hope we will respond in a manner that respects our First Amendment rights, but also respects our responsibility as the Bible talks about loving our neighbors, and that we can do so keeping Breonna Taylor's legacy in mind, but also in a way that respects our Louisville, our city, the city I live in, that respects all of our communities. So again, this is a hard day. I am under no illusion that it is not. And all I can offer is that our office uncovered every fact that was relevant to the wee hours, the morning hours of March 13th. We provided that information to the grand jury, and you all now, whether you're sitting here or whether you're at home, know the results of that process. And now we have the responsibility to prosecute that indictment, move forward in that matter. But all of us have a responsibility to work together, to find common ground, to find ways to love one another, and just be good neighbors. And so that's what I implore as you all report on this in a responsible manner. That's what I implore those that are watching on television, is that we all have the responsibility of coming together now. I hope that you will take that charge seriously. Our governor likes to talk about Team Kentucky, and I believe him earnestly in that charge. And I hope that that extends to the results that were issued here today, and I hope that extends to all of our neighbors and all of our communities. Thank you, and God bless.